Grateful for your time here on Top Story, brought to you by Vodafone. Further together, I'm blessed. And now it is confirmed that founder of defunct Capital Bank, William Atoisian, is just waking up to that sad reality that he will be spending the next 15 years of his lifetime in jail. He was charged with offences ranging from stealing over 90 million cedis belonging to the bank and for various roles he played in the collapse of this very bank. He's also been linked to money laundering and pleaded guilty to all counts. Mr. Asian was supposed to have been sentenced in December 2023, but his judgment was held in abeyance following a settlement agreed which he brokered between himself and the state under Section 35 of the Courts Act. Under this agreement, Mr. Asian was supposed to have paid up to the state some 90 million cedis in 3 tranches, but he defaulted on the payment, giving the state no option but to file a motion for the sentence, which landed him now in jail. Mr. Isian paid 30 million cedis of that amount on December 1, 2022, and per the agreement as adopted by the court, he was ordered to pay the remaining 60 million Ghana cedis in 3 installments, with the first installment on or before April 28, 2023, the second on or before August 2023, and the last installment on or before December 15, 2023. Well, the presiding judge, Justice Eric Che Powerful, in handing him this very sentence, said Mr. Asian had paid only 37 million cedis of the total 90 million cedis. So why is he still being jailed? Let's get more from Richard Kojinyako, who was in court all throughout the day. Joins me in studio now with more. Richard, that's the sad reality of Mr. Asian, but we know that he'll be spending 15 years in jail. Let's first off give a background to the case to our listeners.
So we know the collapse of the Capital Bank, and he was supposed to be sentenced. The judgment was ready in December 2022, but that judgment had to be suspended because all throughout the trial, Mr. Asian had pleaded not guilty to all the count, to all the charges. And so on the very day that judgment was supposed to be given by the judge, he pleaded guilty to all the counts. And so he went under Section 35 of the Court Act that had some agreement read between himself and the state. And the agreement, he was supposed to pay some amount, and then the rest will be spread throughout the period. And so he was supposed to pay 30 million Ghana cedis, and then in April he was supposed to pay 20 million Ghana cedis. On the 31st of August he was supposed to pay 20 million Ghana cedis, and the final payment was supposed to be done in December. But he defaulted in the April payment. He also defaulted in the August payment. And so when we went to court today, the lawyers pleaded for more time. They indicated that if more time is given to Mr. Asian, he has a lot of property around, and since his license was revoked, he's been jobless, he's not been able to travel, his passport has also been seized. And so if given more time, he's demonstrated some utmost good faith, because when the matter came, he readily paid 37 million out of the total of 90 million Ghana cedis. So if given time, such a person will be able to pay. But it gave the state no option. The state said, well, we gave you that opportunity to make yourself or to come clean. And so if you're unable to pay that amount of money, then we have no option than to file a motion. And so the motion for the sentence to be handed him was moved today, but that motion was opposed by lawyers for Mr. Asian. So they raised 2 grounds. The first one was that the man should be given more time because he's demonstrated utmost goodwill. The other one was that he's a family member, he's a family man, he's married with kids and all of that, and the fact that he's demonstrated that he will pay, and there are some property of his that are around for him to even pay. The court should give him that time.
And he speaks of this property right in Accra, which could help to defray a significant portion of that
exactly.
debt.
So he mentioned a property in Pram Pram that is valued at $10 million. And what is left for him to pay is 53 million Ghana cedis. And so if you look at $10 million, he would be able to pay with that kind of amount, and some of them will be left. But the judge said that there has been back and forth, because from the July 27, when the court went on recess, the court also went on vacation for 2 months, and there was an indication the court was expecting that when they resume by today, when they went to court, Mr. Essien would have come to court and say that, well, I found the money, I've gotten the money, and so I'm coming to pay.
So basically, he did not see this coming.
Yes, he came in the company of a very fair-colored, beautiful woman seated by him, and so we suspected that was the wife. So it might come as a surprise, because you wouldn't come this far, and then today you came to court and you expected that you spend the next 15 years in jail.
And we know that there are obviously some mitigating measures that we could possibly be exploring, but many have been, shocked by this latest judgment coming through from the courts, precisely knowing that a lifeline indeed was handed over to Mr. Atoisian, who was then founder of the now defunct Capital Bank. We'll be talking about those mitigating measures shortly, plus further action in court today. But I want to hear from Dr. John Baden, who is a private legal practitioner, joining us over the telephone lines now. Dr. Baden, thank you for spending some time with us here on Top Story. So it's a done deal, you say? Pay up 90 million, walk a free man. He's only been able to raise 37 million Ghana cedis. You feel there's another legal opening for this gentleman, Mr. Atoisian?
Well, that is for his lawyers to really make that determination. But it is just an agreement that has just gone. Do you hear me?
I'm with you, sir.
Yes, I'm saying that it's an agreement that he has reneged upon. That is why he's facing this sanction. I mean, seriously, the thing is, it looks like the view of the law is that he has caused financial loss to the state, and the state was trying to recover the money. And it looks like they are coming up with one excuse after the other, and maybe the state cannot wait anymore. So he gets the sanction.
Also joining us tonight is private legal practitioner Kweku Pencil. Mr. Pencil, you're equally surprised as well that this gentleman was handed a lifeline. He failed to, meet up the payment timelines. But strictly speaking, did you expect that this will get to this point where a jail sentence will come to bear?
Yeah, it's not surprising at all, and it's got nothing to do with his abilities or capability to pay the judgment sum that he was asked to pay. But let me put it this way. At the point that you go into a plea bargain itself starts with an acknowledgement of an admission of guilt. So every time that a matter goes to court, there are two things. I'm talking about criminal action. First is the conviction. Second is the sentencing. So that any time that a party pleads guilty to a matter and he is convicted, he is at the mercy of the court in terms of sentencing. And when it comes to sentencing, depending on the nature of the offense, the punishment is prescribed by law, and it will typically provide for an option of a fine or imprisonment or to both. In almost all cases, only the term would depend on whether it's a misdemeanor or a felony and so forth and so on. So at the point that you pleaded guilty as part of the plea bargain, In other words, at the time that you admitted that you're going on that route, you stand convicted before the court. The rest is the order that the judge made arising upon the terms upon which the parties negotiated or upon which the court gave its consent for the matter to be settled on those terms. In other words, in his case, he was required to pay or remit or pay back to the state a certain sum of money, which I've not really concerned myself with. And therefore, once you default, you go back to where you stood before the court, which is the conviction. The rest is for the judge to sentence. So when the judge sentenced, he was doing what the law required him to do. And obviously, he used his discretion in the circumstances to sentence him to the number of years that the judge felt appropriate. And when it comes to sentencing, obviously, like I've told you, it's a range, and the judge has a discretion to exercise. And once it exercises it, it will hardly be questioned even on appeal, unless you're able to demonstrate that he went beyond bounds. So, to answer your question, the conviction that came as a result of his non-compliance or failure to pay the money that the court ordered that he should pay is not surprising. It's the natural consequences of his non-compliance.
And Richard Kujinyaku, who was in court for us, is still here with us. I want you to stay on with us, gentlemen. The point about the details of the sentencing, because there were two options available to this man, Mr. Atuoisian, either to pay up the 90 million Ghana cedis or to avoid being jailed once that settlement is done. But now it is emerging, Richard, that he would have to deal with the two at once.
Yeah, so in sentencing him, each count had a sentence. So from count 1 up to count 23. So we counted 1 up to 23. So count 1 was 2 years. So the judge explained that even one of the counts, the sentencing should have been 25 years. But because of the plea and the fact that he was able to raise an amount of 37 million out of the 90 million, he made an effort. That is why the sentencing got reduced. So if you put all the sentences in totality, it was 95 years. But because he's serving it concurrently, so the highest of the sentencing was 15 years. And that is why he got 15 years.
And some monetary issues will also come up?
Yeah, exactly. So that was not really explained whether he will go in and then still pay up the remainder of the amount. So I guess the lawyers will explain.
And Dr. John Braden, it's the reason why many believe that this decision by the court probably could be reversed on appeal. What's your take on that?
Are you asking me?
Dr. John Braden?
Why I cannot see it being reversed on appeal. Because, like my colleague has said, this was a subsequent to an agreement, and if he just could not fulfill, his terms of the agreement, then he just deals with the rigors of the law. I can't see how this can be overturned. I cannot see.
Yeah, maybe if I can chip in, once you have been, the plea of guilty. When you plead guilty, the judge has nothing more to do. And once you are convicted on a guilty plea, which is an essential element of the plea bargain, you stand convicted. So you can't appeal against conviction. There can be no ground whatsoever for appeal against conviction. And of course, the other thing is the sentencing. And because there's a discretionary element, obviously, the judge applied discretion, gave reasons for why he gave you in all a total or the maximum of 15. Because as he said, if there was one that he wanted 25, you could have given 25. And when you go before an appeal, the duty of an appeal court is not to substitute its views for that of the trial judge. And whenever discretion is entrusted to anybody, to choose between A and B. If he chooses to do A and he doesn't do B, it does not amount to a dereliction or whatever. In other words, the duty to do A or B implies to do A or B, and that's the way it is. And once the discretion has been exercised in the manner that has been described, I will personally have great difficulty appreciating how a court of appeal would tamper with the judge's use of discretion, unless there's something else that I do not know. So that's the difficulty that Mr. Essien is going to find himself. He himself pleaded guilty and he stands convicted on his own plea. And please don't forget that a court of appeal can exercise its discretion either way. In other words, if the court of appeal has sufficient reason to believe that the judge was unduly and unnecessarily lenient with him, they may increase it. And it has happened. We have records to that effect in our law reports. So anybody who decides to lodge an appeal must weigh that very carefully.
And I'm just looking at the case where you have the individual involved paying up some 37 million Ghana cedis out of the total of 90 million Ghana cedis. The point about retrieving the outstanding amount, is it beyond doable, knowing now that this embattled founder of the defunct Capital Bank is heading to jail?
Oh, you see, I don't know what I've understood you, but I see the mere fact that you've made a part payment is not good consideration, though for purpose of the sentencing, the judge relied on it. But let's put it this way. There is a provision. It's one of the decrees. I cannot quote it specifically, but the courts have power upon convicting anybody in cases where it involves public funds and so forth and so on, in addition to sentencing, or rather in addition to a term of imprisonment, to also impose an obligation or sentence the person to refund the whole amount by attaching the person's properties, or generally make an order empowering the state, for that matter the Attorney General, to go after the person to retrieve the full amount. But it's for the judge to make that specific order. I wouldn't know whether the judge exercised a discretion to apply the provision of that decree. I know that it exists on our record books. It was used in the Asibit case, Asibit Abugapele case. The judge made an order, convicted them, and also made an order directed to the Attorney General to retrieve the full amount from them.
And we might just be finding out if that was or is applicable in this very decree, or judgment, I should say, by the court today. Because we're fortunate to have lawyer Alfred Tioyoba, who happens to be the Deputy Attorney General. He leads this case, and so we'll have a better appreciation of what the implications of this court decision is. Mr. Eboa, thank you for spending time with us here on Top Story. First of all, your reaction to the decision of the court, and is it your interpretation, or perhaps your deduction, that Mr. Essien will be liable to paying up the rest of the amount to make up for the 90 million cedis?
Thank you very much, my brother. Yes, I think this matter last year, as the record will show, there was a decision by the court to adopt our agreement pursuant to Section 35. Now, we were expecting that the convict was going to go by the terms of the agreement. He reneged on that promise, and then we decided to activate our side of the bargain by applying to the court to have him sentenced into prison. Today, we went to court, and then the court did what it was supposed to do in accordance with law. Now, with regard to the outstanding sum, we were able to recover at least 37 million Ghana cedis from him. There's an outstanding sum of about 53 million Ghana cedis. There was the indication that a person may want to pay the outstanding sum. If he pays and he goes on appeal, that may go to the, maybe whether he may want the appeal to reduce if he pays. But the fact that he has not paid means that he's to state that amount of money. And that amount of money, the state will be within its right to pursue him for that money.
And is that something you plan to do?
We are looking at the options. And whatever that we arrive at, definitely you get to know it.
In all of this, of course, my personal impression that you were is that you were very much concerned about the funds itself, the funds which you deem crucial to raking in and clawing back what it is that belongs to the state. Now you have the gentleman at the center of this case heading to jail for the next 15 years. Which one was paramount to you at the time you were pursuing this case? Either making or clawing back the 90 million Ghana cedis, or perhaps just having him behind bars?
Originally, we were looking at the possibility of getting the money. That's why we agreed with him. But we also realized that he was not forthcoming with this side of the agreement. So the next concern we had was that then in that case, he must go to jail. If he had paid the 90 million, we would have avoided custodial sentence. So in terms of the prosecutions, we have been looking at getting convictions as well as recovering amount of money from people who will be convicted. So we're looking at both.
And we know that this is just part of a minute, decision that the government is taking on just a few individuals who have been found culpable of breaching regulations when it comes to the banking sector cleanup. I'm wondering if this is giving you some sort of motivation to go ahead and to go after other individuals cited in various reports about this banking sector breaches.
Yes, we are ready and willing to take on all those who were part of the scheme to have deposited fund lost. And there are cases in court now as we speak. There are other people who are also facing prosecution. Those whose case we have not taken to court should not be thinking that we've forgotten about them. No, it's a process. All the others, including savings and loans and microfinances, we'll get to all of them.
And so what will be the next, if you're willing to disclose that, by the way?
As I said already, we have some cases in court. Some of them are at the advanced stage, and we may want to go along with that. But we add them more. And when we add more, definitely you get to know it. But I'm saying that all those who took part or who were owners of savings and loans and microfinances, who know that because of their actions and inactions, the state has had to cough up money to pay their depositors. We'll be coming after all of them.
I see. And we are indeed grateful that you're speaking to us. But beyond this, some are describing this as a feather in your cap. First of all to you and then to your boss, Godfred Dami, who is or has been criticized over the years for not prosecuting successfully any case of corruption or corruption-related offences, criminal offences against persons who have, in one way or the other, done some infractions that dent or either bring a lot of untoward hardship to people. Do you see this as, an indication that, yes, indeed, you're committed to the cause, committed to the fight against corruption, and trying as much as possible to save state funds?
Yes, we are very much committed to fighting corruption. We are very much committed to fighting all manner of criminal activities. But if we take a matter to court, we are on the one side, the accused person is on that side. It is the court that will determine the pace at which some of these cases may be going. And an accused person has the right to appeal against every order made by the court. So it's not the case pending that have been pending for 3, 4, 5, 6 years. We are doing our part. But the accused person also utilizing the law to also defend their case. So we are committed to it. Despite all the blocks that we may have along the way, we are ready and willing to keep on prosecuting.
And we'll wait to see. Definitely, we'll be following all of your activities in courts. Lawyer Alfred Tioyebo, Deputy Attorney General, joining us now on Top Story. But it's been a packed day in court. Lots of activities happening. The OSP also taking some action on the Cecilia Dapar case. And you've been there monitoring all of this, Kojo.
Yeah, so when we went to court, the Office of the Special Prosecutor had filed a petition before the Chief Justice asking for the removal of Justice Chum to be removed from cases associated with the office of the special prosecutor and himself. He says that per the judge's comment and behavior, he does not see that they will get justice. But the lawyers for Madam Cecilia Dapa, they have been responding, saying that what the OSP is doing is mere repetition of the application. They insisted that the OSP is acting unethically, because if one files a petition before the Chief Justice, it doesn't warrant that the OSP himself will not come to court. And so by mere doing so and not giving them leads or notifying them that indeed this was what he was going to do, he was going to file a petition, and then the act complained of, even the judge did not even know what really they were complaining about. And so on that basis, they were worried.
And you can get the latest details of all of these activities in court today at myjoyonline.com. Wrapping up effectively. Top story here on Joy 99.7 FM. And it's a good time to tell you that Newsnight is next after these messages.